Today, good morning. Today, I'm talking about the basic elements of a real estate contract. But the thing is, they are not just the basic elements of a real estate contract. They are the basic elements of any contract, either real estate, either you go to the shop, you want to buy clothes, either you take your children to school, either you book a travel agency, either you buy something online, either you are getting married, they all have the same basic elements. Either the contract is verbal or in writing, because some contracts are still verbal. For example, you take your child to school, they won't give you a contract to sign. You will ask them questions, they will give you answers. You will ask them what they have, they will tell you what they have. And you will agree. You will talk about some things back and forth and you will agree. So technically that one is not in writing, but it still has these three basic elements for it to be a valid contract. Otherwise, the contract is voidable. The three major elements are offer, acceptance, and consideration. It can get more complex, but this is the basis upon which everything else rests. There must be an offer. For example, in real estate, are you renting a house? Is it a rental or an outright purchase? Is it a long lease? Are you doing a lease of 7 years, 10 years? Or is a yearly lease? Because those facts determine some other things. Is it a rent to own? You understand? Where you are paying a high rent because at the end of it, fixed term, the house is going to be yours. Are you buying a house that is built and you get it the day you pay? Or you are buying off plan that you are paying in installments and you're getting at the end? You understand? You want to buy a dress, you enter a shop, what's the size, what's the color, what's the design? These are essential facts of an offer. Any offer, no matter how complex or mundane, must have these basic elements. So that's an offer. Parties, if the agreement is in writing, because there are some, of course, that it cannot be verbal, has to be in writing. So the terms of that kind of offer will be in writing. Parties will then start exchanging. The party that is making the offer will draft it. He will send it to the other party. The other party will look at it. There can be more than two parties anyway. Can be as many as any number of parties to an agreement. The party that is making the offer will draft it, send it to the other party, will look at it, he will make comments, he will send it back. They will go back and forth and negotiate the terms of the offer. The terms, they can also negotiate the consideration, we will come there. And then when parties agree, the party that didn't draft will then sign. You understand? The party that drafted to will sign, but the party that didn't draft will accept the terms of that offer and sign. Please note that the courts have said that the fact that you didn't sign doesn't mean you didn't accept. Once you begin to take steps on that offer that you have received, you are deemed to have accepted. So if you are not willing to accept the terms of that offer, don't take steps on it. If you are not willing to accept the terms of buying the dress, don't take it home. If you are not willing to accept the terms that the school is offering for them to accept your child, don't pay school fees and start bringing your child. Then you wake up and say, why is there only one teacher in class? When you went to visit the school, they told you it's only one teacher, you didn't complain. You wake up and start saying, why is it only 2 extracurricular? You want your child to take ballet and piano. They told you when you came that they don't have ballet and piano. You cannot start asking that in the afternoon. When you want to supply goods to a company, the company has told you the terms upon which they are going to pay. You have told them the goods you are supplying. Parties should agree on the offer. When you want to render a service, maybe they want to outsource the drivers of the company to you. What do they want? What are you offering? Parties should agree, because once you take steps on an offer that you didn't agree on, you are deemed to have agreed to the terms of that offer. So there is the offer, parties agree on it, there is the acceptance. Even in marriage, there is the acceptance and then there's the consideration. Now, consideration need not be cash. It can be consideration other than cash. That is why, for example, in a deed of gift, what you have is not cash, but you can have, oh, in consideration of the way you helped me when I was broke, I give you this. In consideration of the emotional support you gave to me, I give you this. So that's a deed of gift. And if it's a deed, there must be consideration clause for it to be valid. You can't even register title with the government if you do not have a consideration clause. So there has to be a consideration clause. The other thing about consideration is that consideration need not be sufficient. The meaning of that is that I can sell my house at 1 naira. That's how much I want to sell the house. And the sale will be valid, provided I was not under duress. I did it voluntarily, and provided I was of sound mind. the sale is valid. The court will not say because it was not market value, it was not valid. So if you do not agree to how much the buyer wants to buy, you had better not sell. You had better not agree as the seller, so that you will not wake up tomorrow and say, oh, you want to go to court because what you got was not market value. Consideration need not be sufficient. People need to know this and know this well, so that their contract will be binding and it will have less trouble down the line. Do you have any questions for me? Please share with me in the comment section. I'd like to hear from you. Take care and have a great day. Bye.